Item 34 W3 2783 W18.
Mr. Mannan, the writ petition has been allowed in the sense that the order of second penalty has been set aside. But your prayer for reinstatement has been declined. Because after 13 years in a service like this, we cannot direct. However, he will be deemed to be in service for notionally calculating his pension till the date of the judgment. And then his pension will be recalculated. It will be paid to him with arrear dues. In otherwise, his pension amount will increase.
Only thing is that this period, from now to his period of his retirement, this period, how it will be pensionary period?
No, he will retire. He will be deemed to have been retired from today.
Okay.
But earlier he was getting the pension as per compulsory retirement.
Yes.
That will now stand interfered and his pension will be computed taking his date of retirement as today. That's the, and back wages, we can't give it, no work, no pay. So that is the middle path which has been chosen, but otherwise the order has been interdicted.
Because
But you'll
if
see
it is
the-
reinstated, then only the vacuities will
That's
come.
correct.
Yes.
So there is some correction, you will get it in the afternoon.
Yes.
It will be online. Keep it.
Much.
Item 35 to 37 W7 707 W18 and others.
Writ petitions have been dismissed. The judgment in Naresh Kumar does not apply here. There was a government decision backed by cabinet decision. There is nothing of that sort here. Therefore, the court has held that there was intelligible differential for making a reasonable classification. These are policy matters. State has to say. Some corrections, you will see the order in the evening, it will be uploaded.
May I please, your lordship?
Yes.
May I please, your lordship? My lord, I am playing for listing of an IA on 30th June, my lord. My lord, regarding stay of a communication, my lord, and
All right.
obliged.
May I please, I beg to mention item number 15, my lord, in which my lord steps is required to be taken. I have taken steps today, my lord, morning, my lord.
Mr. JMA Chaudhary, item 15. The Learned Counsel for the petitioner submits that he has taken steps in this case this morning, and therefore this matter be posted again after the vacation for service report. Register to verify and list the matter accordingly. Item 15.
For item number 14, or 15, every, for item number 15,
Yeah.
for respondent 1 to 4,
That's your name, please.
Ali A. Meto.
Mr. A. Mathur, Learned Counsel is present for respondent number 1 to 4.
Yes.
May I please, my lord, with regard to item number 19, my lord, otherwise the matter is ready for hearing. Only thing is, my lord, the man was convicted in that NII one of first case, my lord, the Karbi Anglong NC Hills scam. He was convicted. Against that, my lord, they were removed. I prefer this writ petition. Now that appeal of conviction, my lord, that judgment is under appeal. The hearings have been concluded, the judgment is awaited. My lord can have this matter immediately after the vacation. If the judgment goes against me, my lord, there is nothing here. If it comes in my favor, then my lord will have to.
All right. Mr. UK Nair, Learned Senior Counsel for the petitioner with proper justification has sought posting of this matter again after the summer vacation. Mr. Who is there? Will have counsel for the respondents are present and do not have any objection of the prayer result. In view of the above, let this matter be listed again in the 4th week of July 2023 as a fixed item. Yes,
Much.
19. May I please?
May I please last? My lord, I am paying for listing one motion matter, lordship on title lordship.
What is the matter?
My lord, relating to transfer of posting of GP secretary lordship.
All right.
May it please, your lordship, I beg to mention for listing a matter for admission after vacation, lordship, any date, because he has been terminated from service, lordship. Any date after vacation, lordship.
2nd week of August, choose a date.
Lordship,
2nd week of August, you choose any date and put it.
in July, lordship,
2nd week of August.
2nd week of August.
May I please,
Obliged.
your lordship? With the consent of the other side, I beg to mention item number 33, your lordship.
Yes. Yes. Your form?
Your Lordship, respondent number 5, Your Lordship.
I am for the petitioner, my lord.
Hearing in any case.
My lord, maybe, maybe fixed, my lord.
Mr.
HR does, Your Lordship.
Mr. H. the council appearing for the respondent number 5 has sought adjournment of hearing of this matter with a request to post the case again after the summer vacation. Mr. M. Sharania, the counsel for the petitioner is present and submits that a firm date should be given for hearing of this matter. Taking note of the prayer made by at the bar, the registry is directed to list this case again on 3rd August 2023 at a fixed time.
Obliged.
May I please, your Lordship? Lordship mentioned for listing of a WPC, Lordship,
Listing for what?
for motion on 36, Lordship.
What? 36. What is the matter?
Matter, the petitioner salary of the stop without any inquiry of the department.
I have a similar prayer, my lord. Read petition filed on my lord last Monday, my lord.
Lordship, frame for listing in a motion column, Lordship. One is a transfer matter and another is the challenging the findings on DP, Lordship.
Yes.
Hearing next for withdrawal item 1.
Matter may be withdrawn, my lord. Matter may be withdrawn, my lord.
All right. Mr. A. N. Ahmed, learned counsel for the writ petitioner submits that he has instructions from his clients to withdraw this writ petition. Ms. S. Borua, learned government advocate Assam, and Mr. R. M. Das, learned counsel for the
Water Resource Department.
learned standing counsel for the Water Resources Department, as well as Mr. P. Nayak, learned standing counsel Finance Department are present and do not have any objection if the prayer is allowed. In view of the above, this writ petition stands disposed of on withdrawal.
For motion item 2.
May I please, my lord? My lord, the petition before my lord was a my lord secretary in a cooperative society. It's called Desha Bhakta Homabai Samiti Limited. Now, my lord, what happened was there was some allegation against him, which they presumed, and my lord, they kept him out of that society. Then they wanted an inquiry. My lord, when that was being done, I approached this honorable court on 2 grounds, my lord. That one, that cooperative society on the day when the board took the resolution, it was a non-S body because by the time had already elapsed. And the other one, my lord, the decision was taken in air. There was no material. This honorable court accepted my contention that the board and the date it passed the resolution did not have the jurisdiction. It was a non-S body. But my lord, given the nature of the allegation, this honorable court required the authorities to conduct an inquiry and to take the matter to its logical conclusion. An inquiry was conducted. Then the additional chief secretary passes an order that there is no material against me. In spite of that position, my lord, I am not being allowed now to go back. When I go to the cooperative society, they say the government has done this. They have not passed any order. So we cannot get you back. I appeared before I appealed to the register, filed a representation, still nothing but.
My lord, in fact, on the last occasion, the honorable court directed me to obtain instruction. My lord, in fact, a bunch of papers have been, my lord, given to me. My lord, there is a corresponding FIR, which is, my lord, Satyavari PS case 50/22. That instruction is awaited whether it has resulted in charge sheet or final report, my lord. Number 1. Number 2, my lord, a direction can be given by this honorable court to the board. Under section 38, it is the board who has to take a resolution. My lord, board has to make a party, my lord. Board is not a party. And my lord, in fact, the present incumbent is respondent 5, my lord. So at least, my lord, notice, my lord, I leave it to your lordship.
No, but why can't the register do the needful here?
My lord, in fact, your lordship will kindly see, under the scheme, my lord, register has nothing to do. If your lordship sees under section 38, it is the board, my lord, appointing a removal authority. A direction has to go to the board. Board will adopt a resolution, my lord. Then, my lord, he can be.
But the register has supervisory jurisdiction.
That is correct.
Then
It's correct.
that is there. Which
Yes.
is that provision of the rules?
Yes.
Act, section 6,
38.
38.
38. 38 2.
38, under 38, does the register not have?
No, under 38, it is the board, my board. No,
The register's overall jurisdiction.
my lord, that instruction is awaited regarding the, my lord, the police case. Lordship may take up immediately after vacation, my
My
lord.
lord, we'll have page 27, my lord, if thereafter, my lord.
One by
something
one, please, one by one, please.
is- Register of power to commissioner, register supervisor power. Register of power.
তাকে return 6 বুলি ক'লে, মই চাওঁচোন, হয় ন? Condition of registration, মই জানো।
So what is your instruction as per order dated 22/6/2023?
My lord, instruction is, there is a, my lord, corresponding FIR was registered.
Hmm.
Corresponding FIR was registered.
Hmm.
Now instruction is awaited whether it has resulted in charge sheet or final report, my lord.
No, but that is another matter.
My lord.
What has that got to do with this? Board is not a party, so we'll ask the register cooperative society to invoke his jurisdiction under section 38 and pass appropriate orders,
And that, my lord, is also there
as
with
may be permissible under the law.
49, my lord, 49.
Why
L.
the board is not made a party here?
My lord, because board, they had, my lord, literally said that because the inquiry was done by the government and the order of this honorable court was to pass appropriate
But
order.
Mr. UK and senior counsel listed by Miss
D. Mohanto.
E. Mohanto and counsel appearing for the writ petitioner. Also heard Mr. S.K. Talukdar and standing counsel corporation department Assam. appearing
One of
for-
1 to 4.
Respond numbers 1 to 4. Full stop. The writ petitioner hearing, who was functioning as the secretary of the Deshabhakta Samavay Samiti Limited, was suspended on the basis of a resolution adopted by the board of directors, and thereafter he was removed from service.
No, my lord,
No,
it was not removed, only
suspended.
kept that suspension.
Full stop. However, according to the petitioner, the board did not have the jurisdiction to pass the order of suspension, since it was non-est on the date of issuing, on the date of initiating such action.
Gotcha.
Full stop. Taking note of the submission of the petitioner's counsel, this court had passed the following order on 22/6/2023. Quote the order. Yeah. Full stop. Today, when the matter is called up, Mr. Talukdar submits an instruction that although no material has been found against the petitioner to substantiate the allegation, yet
In the inquiry,
allegation in the inquiry,
My-
in the departmental
my
inquiry,
lord.
yet since there is an FIR registered on the allegation, hence he needs-
Satyabari PS case 50/22,
based on which Satyabari PS case number
50/22.
50/2022 has been registered under sections
Section, my lord, 406, 420.
406/420 of
IPC.
IPC. He be granted some more time to take instruction in the matter. Full stop.
50/22.
The fact of the matter, the fact remains that this court had directed the department to conduct an inquiry against the petitioner, considering the nature of allegation brought against him. And the said inquiry has revealed that there is no material to substantiate the allegation. Full stop. Therefore, merely because a police case has been registered based on an FIR lodged in the matter, the same, in the opinion of this court, cannot be a justification for
No.
continuing.
Lordship will record my submission that is awaited. I don't know whether, my lord, this is the basis, my lord.
No, case has been registered.
Yes, yes.
That cannot be a justification for keeping the petitioner out of office. Full stop. Next, this court has also noticed that the board of directors of the Samavay Samiti Limited is not a party in this case. However, under section 38 of the Assam Cooperative Societies Act 2007, the Register of Cooperative Society has overall supervisory jurisdiction over the functionings of the cooperative societies. Full stop. Therefore, this writ petition is being disposed of with a direction upon the respondent number.
My lord, register is respondent, my lord. He is
Respondent number
respondent
two.
number two, my
That is
lord.
the register of cooperative
Respondent.
societies to invoke his powers under section 38 of the Act of 2007 and pass appropriate orders for redressal of petitioner's grievances in the light of the observation made herein above. The order be passed as expeditiously as possible, but not later than 2 weeks from the date of receipt of a certified copy of the order.
My lord, there is one.
38 read with 49L.
38
49L.
read with 49L of the Act of 2007.
My lord will say something regarding respondent five.
Because he is there on temporary basis. Man.
That is a stopgap.
Stopgap
arrangement.
arrangement.
Register, you advise.
No,
him-
what I'm trying to say, lordship will indicate no notice is required to him, my lord, because your lordship has not dealt with respondent five. Only that much.
He is there
Insofar
on
as the
temporary
respondent number 5 is
Yes.
concerned, since his engagement as secretary is as a
Adopt.
stopgap
Yes.
arrangement. The said aspect of the matter need not come in the way
Yes.
of passing
Well.
appropriate order.
Yes.
That may be justified in the facts of the case.
God bless, much.
With the above observation, stands disposed. Yes. Yes.
Confusion in regard to the data part of the petitioner. As per the metric certificate, he has
This
to,
matter has to wait. We can't.
yes, sir. So, my lord, they have.
Sir,
said that he
I
is not-
have verbal instructions, my lord. The papers are being processed and he need not come to duty now. Because he's processing process and he is will be relieved in his very short days, short time. my lord.
That may be recorded, my lord. Notices may go. my lord. Otherwise, they will ask for refund later.
Take down heard Mr. B D Cole, Senate Council appearing for the writ petition, also heard Mr. D Gogoi, and Standing Council, Forest Department, Assam, who submits on instruction that the papers of the petitioner are being processed.
Process, my-
Processed for what?
process for my lord, releasing him from duty and giving him the supervision dues, my lord.
For releasing him from duty and also for disbursing the superannuation dues. And therefore, this matter be posted again after the vacation so as to enable the department to complete the process. Mr. Gogoi also submits that the writ petitioner need not need not report for duty in the meantime.
Right.
In view of the above, let this matter be listed again for motion on 24th of July. to the-
24th, I will be with 20th, my lord. 20.
But 20.
My lord, he shall cooperate, my lord.
Huh?
Because there's a, I have submitted that he need not join, not go for
But
duty,
that
but
is
he will
not
cooperate.
joined. However, the petitioner shall render all cooperation to the departmental authorities for completion of the process. List again on
Published.
28. 28. 28 July.
Published.
May I please, your lordship?
Yes.
Petitioner is the assistant librarian working in Institute of Advanced Studies in Science and Technology. When the institute was under the government Assam, he is the promotional channel. And when after taking up with the government by the union, promotional channel has been cut and it is against the settled position of law.
Will issue notice at this stage. Heard Mr. S. Nath, Learned Counsel for the petitioner. The writ petitioner who is serving as assistant librarian under the
In the Institute of Advanced Studies in Science and Technology.
in the Institute of Advanced Study in Science and Technology, Guwahati, is aggrieved by the curtailment of his promotional avenues and therefore has approached this court by filing the instant writ petition. First up, Mr. UK Goswami, Lanet CGC, as well as Miss
P. Agarwal for respondent number 5 UGC,
Ms. E. Agarwal, Lanet Standing Council UGC,
panel advocate.
Lanet Panel Advocate UGC are present and pray for some time to obtain instruction in the matter. NOM 6 weeks, since Mr. Goswami has accepted notice for respondent numbers 1 to 4 and Ms. Agarwal for respondent number 5, no formal notice is required to be sent in this case. Extra copies, requisite numbers. Requisite in numbers.
Lordship, in this case, Lordship, the petitioner has already filed a statutory appeal before the Lower Assam Commission around 3rd of March. Lordship, but not a single hearing has taken place. So Lordship, I am praying for a similar order at page 78 or page 81, Lordship. Wherein your Lordship has given protection, Lordship.
interim protection.
No, my lord,
And the response number seven has not been appointed till that, Lordship. Out of Lordship 94 selected persons, 66 have been appointed, and appointment of 28 candidates have been withheld, Lordship.
Let the appeal be disposed of.
Yeah, that may be disposed of, but interim order, my lord, the fact is different. He says only any criminal case is pending against respondent number 7. The different thing, my lord, he is not a trial. That's the different thing, my
No,
lord.
no, let the, since an appeal is,
That may be, my lord, disposed of within, but
and then before that, he will be appointed.
no, I don't know, my lord, whether appointment or made.
If it has not been done already, then it will await the outcome of the appeal, that's all. Once an allegation is given.
That is true. In appeal also, he prayed like that, but to suspend his appointment. There is, prayer is there. He can agitate it before the blood commissioner.
All right, you have made your submissions. All right, heard Mr. S.K. Das, learned counsel for the petitioner. The petitioner herein had submitted his application pursuant to the advertisement notice dated 3/9/2022 for appointment in the post of Gaon Pradhan in respect of charge number 13, Moja Borpeta under Borpeta Revenue Circle. Full stop. The petitioner, along with other candidates, had also appeared in the interview process. However, on conclusion of the process, a list of selected candidates was published wherein the name of the respondent number 7 finds place for appointment as Gaon Pradhan of charge number 13 given way to the association. Aggrieved by the said selection, the petitioner had submitted an appeal under Rule 162(c). 162(c), is it? Of the executive instructions framed under Rule under the Assam Land and Revenue Regulations, 1886, assailing the selection of respondent number 7 internally on the ground that due to a pendency of a criminal case against the said candidate, he cannot be appointed as Gaon Pradhan. Full stop. According to Mr. Das, the appeal was submitted on 3/3/2023. Full stop. However, till date, no hearing has been held in the appeal, as a result of which the petitioner has been compelled to approach this court by filing the instant writ petition with a prayer for an interim order. Full stop. Mr. T.C. Chutia, learned additional senior government advocate Assam, as well as Mr. S. Datta, learned standing counsel Revenue Department Assam, have fairly submitted that since an appeal has been preferred under the statute, under the provisions of the statute, the same ought to be decided on merit. However, due to lapse of time, no interim order be passed at this stage. Full stop. There is no doubt or dispute about the fact that a statutory appeal questioning the selection of a candidate for appointment in the post of Gram Pradhan is maintainable, is permissible under the law. And in this case, the petitioner has also preferred an appeal before the respondent number 3. Full stop. If that be so, the appeal is required to be considered on merit. An appropriate order is necessary to be passed in the matter, which apparently has not been done till today. Full stop. Moreover, if an allegation is brought against the respondent number 3 by filing an appeal, his appointment cannot be processed unless the issue is answered by the statutory authority. In view of the above and considering the facts and circumstances of the case in its entirety, this writ petition is being disposed of at the motion stage by providing that the appeal preferred by the petitioner be considered on merit and disposed of as expeditiously as possible, but not later than 60 days from the date of receipt of a certified copy of this order. Until such time, no order of appointment shall be issued in favor of respondent number 7, if not already done.
Lordship, in the last part of the order, Lordship, I had respondent number 3, it should be respondent number 7. Lordship. In the last part of the order, your Lordship said respondent number 3, it should be respondent number 7.
Respondent number 3, you have preferred the appeal.
Yes.
Respondent number 7's appointment. It's been given. Don't worry. We are capable of handling this much, Mr. Das. May not be so much, but only this much we are capable. Yes. Yes, what is it?
May I please, your lordship? Lordship, we applied for the post of constable GDA through requirement of.
It's a covered matter.
Lordship.
Yes, your name, please.
H. Ahmed.
Mr. H. Ahmed for the petitioners, multiple petition. Mr. S. S. Roy, Leonard CGC, disposed of.
Lordship.
Applied.
Same order, cycle level, bigger, but for level. Put changes to the level petitioners.
Item 7.
The petitioners are engaged in the Brahmaputra board, they are working since last more than 20 years. Some of them even working for 28 years.
We need to notice at this stage, but Mr. N. K. Kalita and counsel for the petitioner, peruse the amendments made in the writ petition. The prayer of the petitioners is for regularization of their service. Taking note of the long and continuous years of service rendered by them. Mr. R.K.D. Chaudhary, learned DSGI, appearing for the respondents, pray for some time to obtain instructions. NOM 8 weeks since Mr. Dev Chaudhary has accepted notice for respond numbers.
All.
For all the respondents, no formal notice, extra copies.
Item 8.
Constable, my lords.
Constable,
OBC can do. OBC can do.
OBC, Mr.
8 and
K.
11 also, Lordship.
Subject to availability of vacancy.
Lordship.
How many petitioner? Single
One,
petitioner.
only one.
OBC, single petitioner, OBC, Mr. K. R. Patgiri, SS Roy, disposed of. And
Item
one-
number 11 also.
Item number 11 also, Mr. H.
H. R. Ahmed.
H. R. Ahmed. That
OBC.
also single petitioner,
Single petition OBC.
single petitioner, OBC, Mr. SS Roy, disposed of both.
Obliged.
Item 9.
My lord, petitioner is differently able person, my lord. She got selected, my lord, thereafter, my lord, in medical, she has been
So some matters are fixed when?
on
Similar
30,
matter,
on 30,
On 30th.
yes.
We'll have it on 30th along with the other matters. In the meantime, you obtain instruction. You are appearing for whom?
Lordship, respond number 1, 2, and 3.
All right. Can you give the case
Not,
number?
Lordship, not 3, 4. 1, 2, and 4.
Can you give the case number?
Connected check, 9.
Then we'll issue notice application.
Yes, my lord. My lord, kindly see one thing, my lord. Some irregularities has been already committed by.
But we'll have to issue notice only. You are not ready with the case number. You want quick orders, you have to come quick preparation. You don't come with quick preparation, no quick order.
My lord, this is-
It can't be that I'll do nothing, but I want everything. That,
my lord, then it may be fixed on 30th.
huh?
Maybe
obtain
taken up on
instruction.
That modern law's case, my lord, since my lord, participation.
You are ready for a final hearing today on the
No.
merit?
I'm
Then we
not
are
ready.
fixing it on 30th.
My lord, 30.
Yes. Heard Mr. R. S. Chauhan for the petitioner. Also heard Mr. C. Sharma, Learned Counsel, appearing for respond numbers 1, 2, and 4. And Mr. P.J. Saikya, P.J. Fukan, sorry. Learned Standing Council, Guwahati University for respond number 3.
My lord.
The Learned Standing Council pray for posting this matter again on 30th of June 2023, so as to enable them to obtain preliminary instruction responding to the allegations made in the writ petition. Prayer allowed, one extra copy each be furnished to Mr. Sharma and Mr. Fukan and Mr. Sharma during the course of the day.
Most of them.
Item 10.
May it please your lordship. Lordship, this is a lordship selection and appointment of a Gaugura lordship. Here lordship, down the list has been already lordship appointed out of 94 lordships, 66 has been appointed lordship. But
You
the-
prefer appeal?
yes, lordship.
You prefer appeal?
No, he have to file an appeal first.
You file an appeal. You withdraw it with liberty to file appeal. Will you?
Lordship,
You have to file an appeal. So many orders have been passed by this.
lordship, things is that lordship, his representation has not been considered till date, lordship, a maiden representation.
No, appeal.
The mandatory
Yes.
appeal is there, Lordship.
Statutory.
Yes.
Mr. S.B. Chaudhary, Mr. B. Chaudhary, Learned Counsel for the petitioner, seeks leave of this court to withdraw this writ petition with liberty to prefer a statutory appeal under Rule 162 bracket C bracket close of the executive instructions framed under the Assam Land and Revenue Regulations, 1886, assailing the selection of the private respondent for appointment in the post of
No private,
Lordship.
no private respondent, Lordship. This petitioner is selected as its serial number 26, Lordship. Down the list, Lordship, others were appointed, Lordship. This petitioners were not till date considered, Lordship.
Oh, then this is not a case of appeal.
Yes, Lordship.
No, Lordship. Here in this case, kindly see the page number 26, Lordship.
All right, now I understand. You are not projecting the correct facts. What is the appeal to be decided here?
Lordship, here in this case, Lordship, in page number 26, this is the appointment list, Lordship. List for the appointment, Lordship. Here in this case, Lordship, 26, serial number 26, 26 charge for Borpeta, Lordship.
Where
And
is the
in charge
representation?
3, serial number 25.
Where is the representation?
Another,
That is on
another
page,
person was
Lordship,
appointed.
page 28, Lordship. I am for charge 3, Lordship.
Yes.
And selection list,
Who is to
Lordship,
issue the order of appointment?
Lordship on page 18, Lordship.
Deputy Commissioner, Lordship.
Then why have you submitted representation before the commissioner?
Yes.
Deputy commissioner is the appointing authority.
Yes, Lordship.
Then why have you represented before the commissioner?
And I made a first representation, Lordship.
Next,
Uh,
please.
Huh?
Page 29. These are submitted before the deputy commissioner also. Page 29. Maybe
Yep.
type copy this.
Type copy, Lordship. Page 29, Lordship.
Take down heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. S. Datta, learned FC Revenue Department Assam, as well as Mr. J. K. Goswami, learned additional senior government advocate Assam, appearing for the state.
3, 4, and 5, Lordship.
Is on one, Mr. Goswami, for 3, 4. Huh?
1 and 2.
1 and 2 and 3, 4 and 5. Mr. The read petitioner hearing had participated in the process for selection of Gram Pradhans in terms of the advertisement notice dated 3/9/2022, whereafter he was selected for appointment as the Gram Pradhan of charge number 3 of Borpeta Moja of Borpeta Revenue Circle. In other words, the petitioner was one of the candidates whose name appeared in the consolidated select list of 94 selected candidates, published on
Lordship, 3/1/2023, Lordship.
3/1/2023. The grievance of the petitioner is that despite his selection, no order of appointment has been made till today. First up, Mr. Chaudhary has invited the attention of this court to the representation submitted by the petitioner on 9/5/2023. Before,
Lordship. Yes, Lordship. Kindly see the page 26, Lordship. Page 26, serial number 25, Lordship. These are the hereby appointed candidate, Lordship. Appointed person, Lordship. Page 25, charge 3, Borpeta. Revenue
right,
charge.
where is the select list?
Select list, Lordship, will find on page 18, Lordship.
And the name of the petitioner?
Page serial number 26, Lordship.
But the select list dated 3/1/2023, this is wherein the name of the petitioner appears at serial number 26. Times the grievance of the petitioner is that despite his selection, no appointment has been made. What are you trying to say, Mr. Goswami?
Lordship, here annex 2, annexure 3, Lordship. Annexure 3 in two sides, Lordship. One is page number 18, another is page number 26, Lordship.
Mr. Goswami, terms of representation, dated so and so, ventilating his grievance in the matter before the respond number. 4, first up, alleging that no action has been taken in the matter till date, the instant writ petition has been filed. Mr. Goswami, learned government advocate Assam, on the other hand, has invited the attention of this court to another select list at annexure Roman 3. What is this annexure Roman 3?
Lordship, this is the appointment letter, Lordship, for the Gaon Pradhan in charge of the shore against the name, Lordship. These are the person, Lordship.
Invited the attention of the court to annexure 3, which is the list of candidates who have already been appointed. First up, be that as it may, the name of the petitioner, although present in the list of selected candidates, does not find place, comma D, does not find place in the second list, which contains the name of Gaon Pradhans who have already been appointed. In view of the above, without expressing any opinion on the merit of the claim of the petitioner, this writ petition stands disposed of with a direction upon the respond number 4 to look into the matter in the light of the representation submitted by the petitioner and take appropriate steps as may be permissible under the law. First up, writ petition stands correct.
Highly obliged, Lordship. Obliged, Lordship.
Supplementary release from motion item 14.
Here in this case, Lordship, subsequently we have filed a comprehensive writ petition, Lordship, because Lordship, the posting question, Lordship, which we have paid for accommodation, they have already approved, Lordship. In their preliminary affidavit, Lordship, they have admitted it, Lordship. So let both.
You have filed another writ
Lordship,
petition.
Lordship.
We will close this by keeping all issues open to be decided in the other writ petition.
Meanwhile, Lordship, that selected candidate will be allowed to join subject to outcome their writ petition, Lordship. Candidate who has been selected may be allowed to join, Lordship, but subject to outcome their writ
No,
petition.
Lordship, if both matter come together, Lordship, then we'll dispose, withdraw, Lordship. But
No,
thing is
maybe
that-
could be.
Thing
they
is
are
that,
not-
Lordship, with the subsequent development which have arose, Lordship, we cannot bring it record on amendment petition, Lordship, which is why we have filed this
What is-
amended comprehensive writ petition, Lordship.
In this case, your lordship had directed them to file an affidavit. In this affidavit, my lord, they have annexed that approval of the governing body. In spite of your lordships having recorded our apprehension prior to that, my lord, that we were worried that they will approve it, my lord. But anyway, they have passed it. But since they have passed, approved it, so and appointed the respond number 7. So therefore, we have to challenge it. So we have filed a comprehensive petition incorporating that along with the earlier cause of action. And that we have filed yesterday. But
What is the comprehensive writ petition number?
Filing number is, yesterday we have filed, Lordship.
7892/23.
7892/2000.
23, my lord, dated 27/6 yesterday.
In fact, the selection had taken place prior to filing with writ petition, Lordship. Approval was a continuous process. It was approved on 23rd, but selection had taken place prior to filing with the writ petition, Lordship. At Lordship direction, we have filed preliminary affidavit also that will clarify our stand.
So is there any interim order?
No,
No interim order so far. No,
Your lordship had recorded our apprehension that they are going to approve it. That's what we submitted.
So if
and
there is
then-
no interim order, you appoint, what is the problem?
Lordship. Selection
But Mr.
affidavit,
Goswami, since you have filed a comprehensive writ petition, we'll close this by saying that all
On that
issues.
day, my lord, your lordship may close.
Huh?
On that day, my lord, whenever it is listed next. year. On that day, definitely it will have no, but let it come together, no?
it will
All right,
come
or
up
Mr.
after the
B. D.
vacation.
Goswami, learned
Meanwhile,
counsel appearing for the petitioners who submits that during the pendency of this writ petition, the governing body of the board.
The Board of Governors.
The Board of Governors have approved the selection of respond number 7 for appointment in the post of
Assistant
Assistant
Registrar.
Registrar, Lordship.
assistant register. And therefore, another writ petition under filing number 7892 of 2023, dated 27/6/2023 has been filed. Assailing the selection as well as the approval of the Board of Governors, which is yet to be listed before this court. As such, a prayer has been made to list this matter along with the aforesaid writ petition. Mr. R.P. Kakoti, learned senior counsel assisted by Mr. A.B. Day, appearing for the IITG, on the other hand, submits that since the
Selection had taken place prior to that filing the writ petition.
selection had taken place prior to the filing
Of the writ
writ petition. And this, and the appointment of respondent number 7 has already received the approval of the board. The IITG be permitted to appoint the respondent number 7. Full stop. The learned senior counsel has however admitted that there is no interim order restraining the respondents from issuing the order of appointment. In view of the above, save and accept directing that this matter be listed along with the other writ petition filed on 27/6/2023. This court does not deem it necessary to pass any other order at this stage.
Outcome, we can appoint a selected
I
candidate.
have clarified that there is no interim order.
It will come on, my lord, day after tomorrow or
Tomorrow will be.
After the vacation, lot in that case.
on 17. On 7,
On 17,
as motion.
17/7/2023 for motion. Both the
Much of-
matters will come together.
Much.
Obliged.
My lord, I appear in item number 43 on, my lord,
You have turned ASTC from bus service to taxi service. What more do you want now?
Cosine. My lord, what I pray, my lord, on 26th, we filed a affidavit in reply to their affidavit in opposition. So far, in my case, there is no stay order, but on the day when we filed an affidavit, my lord, there is a further communication to the government. We'd like to bring it on record along with all the documents which they are most likely to have it. And your lordship will take my so far item number 43, your lordship may take it up immediately after reopening of the vacation, my lord. Because it will take some time of hearing, my lord. And since your lordship can look into these documents, now they are, after filing of our reply, they are seeking for all these documents. Of course, it's not very clean to read it, but it's legible, my lord. We have taken out a printout from the WhatsApp, we'll get the document.
Acha, first of all, how many matters are there?
3 matters, man.
Item numbers?
41, 42, and 43. I appear in item number 43, where there is no interim. And my lord, notices are yet to be issued in my case because your lordship has on day 1 when your lordship was
And
not reluctant to
in
grant.
41 and 42, who's appearing? Yes, you are appearing in which item? 41. Is there an interim order there?
No, my lord, it has, no notice has been issued yet. First time it is being heard.
And yes.
There are only 3 persons are there, even if your lordship extend the interim order till reopening, my lord. The others.
So far as one item is concerned, item 42, where there is a stay order, we have filed the affidavit, so that stay order was not indefinite. So lordship may consider whether that interim order is to be further extended or not. Because we have brought all the facts and the whole basis of the interim order is not based on facts actually. Then that
Just a minute. Let us first deal with 41 and 43.
41, 43, I have no objection after vacation because there is no stay order operating.
28 of on
Yes.
28, my lord, my friend is there.
So
I
we'll
cannot know,
issue-
but will definitely be here.
We'll issue notice fixing it on 28th of July and keep the prayer for interim relief open.
But in 41, interim may kindly be granted because we are individuals who have come, who have been retrenched here.
No, but how can the court grant some case interim in some other case?
In
no
my
interim?
lord, in
Then
40,
you have to argue, you have to satisfy the court. That you can do today, but in that case, the prayer will either be granted or rejected.
my lord.
You can do it today if you want. The court will either grant it or reject it. Or you can make an attempt on the next date when the other matter is there. You decide what you want to do.
Lordship may not reject it. In their case, we are similarly situated, similarly appointed, my lord. In item 43, my lord.
But after we have filed the affidavit, bringing all facts on board, lordship, whether that interim order can be passed or not, because on the day when the interim order was passed, our side, the facts were not placed. The facts are very loud and clear.
Acha, Mr. Saikia, leaving aside the technicalities, tell us, the large number of people are affected. So they will be left at the lurch.
No, they can always come back when the phase recruitment process will start. Because these people, without any advertisement, they know some officers, two persons.
They will be overrated by that time.
That lordship may take call because we have to think about those persons who are in the market and who have not got the opportunity of engagement. And these people only because of by dint of their close connection with that then MD, two MDs were named. They got into the service. That is sheer violation of Article 14.
So any action initiated against the MD?
It is in the process because very recently we have come to know all these things. Last 2 months, these are the developments. So we are going to take action against two of the directors. I can name them also. But at the same time, whether we take action or not, action is definitely contemplated. That is in the meeting. It has been very clearly found out, very clearly resolved that action will be taken, start the process of action against the erring two MDs. That's a part of the record also. So that process will be parallelly, it will be continuing. But whether we take action against those two persons or not, that will not give them any rights to continue. Because their right has to come from the Constitution of India, that they have to be a part of a selection process where everybody is given equal opportunity. That is the level playing field. There was no advertisement. So out of 2,200 lordship, we have removed only 771. Rest who have come through due process of law as enshrined in our Constitution. The mandate of the Constitution has been followed. They are unaffected.
Acha, Mr. Kaur, it is not your case that you have been terminated in a selective manner, pick and choose manner.
But your lordship will say, without any inquiry, the last document of the AST itself, it is after our termination. Now they are calling for the record when we have taken a ground. Without any due process of inquiry, you have terminated us. And all of us are, in some cases, there was in fact a selection procedure. That's why your lordship will look
So
into
termination order is dated
38th of May.
They are already out of service.
Yes, all of.
In your case also, they are out of service.
Yes.
And very important factor, lordship, that they are all contractual employees and their contract period is already over. The law is again well settled. The Honorable Court will not direct for continuation of a contract period.
There is no document to show that we are contractual employees. We have been terminated our contract. Those documents are not there. We will not argue on merit. But I have what has fallen from my friends is that they are going to take action against those MDs also. Let that be also be placed on record on the next day. What action they are contemplating.
This is not their prayer in the repetition. Let them file a PIL.
My lord, your lordship can always mold the relief, my lord, in a repetition. I did not say.
In item 43, give me the record of item 43. In item 43, you write, heard Mr. B.D. Cole and its senior counsel, assisted by Mr. P. Gupta and its counsel appearing for lead petitioners. Also heard Mr. D. Saikal and Advocate General Assam, assisted by Mr. P. Nayak, learned counsel appearing for the respondents. I have perused the pleadings in the writ petition as well as the preliminary affidavit filed by the respondents. The petitioners have also filed their rejoinder. However, the petitioner, how many petitioners are there?
Well, we are for the association. We are not for
The petitioner association has also filed its rejoinder. However, Mr. B.D. Kaur and its senior counsel for the petitioner submits that in view of certain subsequent developments taking place in the matter, this writ petition be posted again on 28/7/2023 so as to enable him to obtain updated instruction and file additional pleadings if so needed. Mr. Saikia and AG Assam does not have any objection to the said prayer. In view of the above, issue notice returnable on 28/7/2023. Since Mr. Nayak has appeared and accepted notice on behalf of all the respondents. All the respondents, no formal notice is required to be sent in this case. Extra copy of the writ petition be furnished to the learned departmental council within a week from today. Heard on the prayer of interim relief. The said prayer will be considered on the returnable date. Registry to list this matter along with item 41 and 43. This is insofar as 43. Where is 41? Item 41? Item 41. Item 41. Item 41, Mr. Day will put it along with the other matter. Heard Mr. S. Day, learned counsel for the petitioner, also heard Mr. D. Sekar, learned. You filed your affidavit in this case?
For the first time it has come, oh no, in the in Vijay Kumar Singh, the first time it has come, so we'll file affidavit. In fact, we'll rely on the same affidavit.
Okay.
We can give a copy of the affidavit which we have
Mr. D.
filed.
Sekar, learned AG Assam, appearing for the assisted by Mr. P. Nayak, appearing for the respondent, submit that the affidavit filed in item 43 will cover the issues raised in the writ petition, and therefore a copy of the said affidavit will be served upon the petitioner's counsel. Full stop. It appears that another writ petition, that is item 43, raising the same issue, is pending disposal before this court and has been fixed on 28/7/2023. As such, issue notice returnable on 28/7/2023. Since the respondents are already represented, no formal notice is required to be sent in this case. Let the matter be listed along with item 43. Heard on the prayer of interim relief, the said prayer will be considered on the returnable date. We'll consider on that day. Yes, now give me item 42.
May I pray for a short time to file the rejoinder? Otherwise, I can argue also, my lord. The detailed order of 9/6/23 was passed. Basically, my lords, they have filed an application seeking vacation of this order, my lord, but it is still the returnable date. Basically, my lord, the point on which
The order has already got vacated.
no, it is not, my lord. Your lordship has extended it on the last occasion also. If your lordship sees, my lord, it's a detailed order of 9/6/23.
No, what is the case here?
The same, my lord. Here, there are only 3 mechanic trainees involved. The notification on the third ingredient is that on verification, it must be proved that there was no selection procedure. The engagement must be without, if your lordship sees at page 45, 30th May 23, this is the notification by which termination has taken place. In pursuance of the minutes of meeting of the ASTC chaired by so-and-so, by the Honorable Chief Minister, dated so-and-so in the conference hall of the Chief Minister, and as per approval of the Board of Directors, meeting so-and-so, those who were engaged purely on contractual basis, on payment of fixed consolidated remuneration per month, and the third ingredient is what I lay emphasis, and which on verification found to be engaged without following any recruitment procedure. That is a condition precedent, a verification process, which finds that there was no recruitment, any recruitment procedure at all. So in this case, if your lordship, from page 26 onwards, the entire documentation is there, but if your lordship now sees the order, your lordship will appreciate. The learned single judge has come to a finding that contrary to, apart from being absent, that ingredient absent, the records show that they were employed, engaged through a recruitment process. If your lordship, may I read, my lords, the first order 9/6/23. My lord.
No, Mr. Goswami,
My-
please tell me one thing.
My,
Your clients were in contractual engagement.
there is no doubt, my lord, but there, I was appointed through a select list that in the counter admit. There was a select list, there was an interview. I participated in the interview, 39 names were there who participated, a select list was prepared. Out of that, initially 10 were appointed, I was not appointed, engaged at that point of time. 3 did not join, therefore 3 additional vacancies came about. I came there, and that is an admitted position, if your lordship, in the reply at page 53, 54. If your lordship, at 53 of the reply, they themselves say there is a select list.
The state has filed a affidavit.
Yes,
here.
my lord, I'm reading from their affidavit in reply.
Yeah,
Internal page 53.
We filed it day before yesterday. It may not be in the record. We filed it day before yesterday.
Acha, Mr. Saikia, will let the affidavit come, let
That
him
is-
file his rejoinder. Same day, we'll thrash it out.
Right.
Either ways, there can't be a piecemeal approach. Heard Mr. P.K. Goswami, Parthiv Kumar Goswami, learned senior counsel listed by Mr. Swenson, appearing for the writ petitioner. Also heard Mr. D. Saikia, learned advocate general Assam, assisted by Mr. P. Nayak, appearing for the state, who submits that the state has filed a counter affidavit in this case. However, the counter affidavit is not on record. The learned senior counsel for the petitioner also prays for some time to file a short rejoinder. Mr. In view of the above and considering the fact that other similar matters are fixed before this court on 28/7/2023, this writ petition is also directed to be posted along with item numbers 41 and 43 on 28/7/2023 as fixed item. In the meantime, parties to exchange pleadings. Interim order passed earlier to continue till then.
Only one submission, lordship, that this matter may be considered for final disposal on that day, lordship. The other case, lordship, is considering fixing it for consideration of the interim prayer. So for
No.
this is
We may take it up for final disposal also.
this specific, because in the other cases,
Other
there-
matters, the prayer for interim relief is kept open for the
Open.
next day. Here.
here the pleadings will be all complete,
We'll take it up.
lordship,
Deeply obliged, man, deeply obliged.
highly obliged.
But Mr. Goswami, the issue is this. Though we are not hearing the matter, matter may not be heard by bench this or bench that, but one important factor is if these are equitable reliefs. So if the state comes up with a plea that in violation of the principles of Article 14 and 16 appointments have been made, then how can the writ court grant relief in equity? That is a matter
What-
you'll have to argue.
Your lordship is absolutely right. Only in this case, we are relying on their own notification that because third ingredient says that there must be absence of any recruitment process. So we are saying.
So you're saying your case, your
is
case
out
is
of
different.
the- Because there was a total selection process. There may not be an advertisement. A list of people were called from the exchange, employment exchange, selection committee was constituted, interview took place, select list was prepared, then appointment took place. And now we are about 8-9 years in service.
Right, you finally rejoinder bringing this.
Deeply obliged, man, deeply.
Highly.
Item 44.
May I please your lordship?
Yes.
My lord, petition of the board lordship, which apart from which hearing impairment, according to disability board has issued him certificate up to 55%. Thereafter, on the basis of this certificate, I applied for the post diesel mechanic, advertisement issued by ONGC Miller. And thereafter, I appeared select list, though I could not produce, but offer of appointment is issued Miller. There is a formalities when after appointment, I have to fill up some forms, including one medical form. There, when medical forms,
Yes.
I went to medical officer for filling up. Now medical officer, ONGC is saying, no, you bring the permanent disability certificate. Up to that, it is all right. Then I approached again disability board chairman that this is the reason, because my validity is given up to temporary, given up to 20, up to year of 25, up to 25, today 23, up to year of 25 years. It is given year of 25. Now they are saying
that now as per rule, we cannot give you again another certificate. Because after 3 years only we can give. After date, that is 25/5 of 2025 only we can give. Now, they have given me an email notice that if you do not produce the permanent this certificate, I will cancel automatically cancel by tomorrow, day after tomorrow. That is why now on the basis of same certificate, which says now I am shown before the medical officer, I appeared on the basis of said medical certificate, my lord, and I was allowed to appear. Then I have selected, I was offered appointment.
Where is the communication of cancel that it will be?
Last
cancelled?
one, my lord, that is last page. Last page, that is page 64. Even for Dinesh, I have typed also, anyhow, it is also.
This is
legible.
by the ONGC authorities.
Yes, this is by ONGC authorities.
But who is the council for?
Here, my lord, I have inquired, they have a panel of councils. Initially, they don't take the copies, it will go. Thereafter, there will be some council will be allotted. They have, I think, 5 or 6 councils, but I requested all, but they are saying we cannot take now because it is we are in a panel council. Another is there, my lord, I party health officer also. Here, my lord, I will be benefited if government medical board also is giving me, again reviewing me, giving this certificate then also, because and otherwise on the other law point, my lord, just on the basis of saying once I'm allowed to appear, I offered appointment, they are saying having selected me, now whether they can go back or not. That is the question before Lord. I'll put you.
But Mr. C. Borwell or a counsel for the petitioner, the read petitioner hearing is suffering from 55% disability, full stop, pursuant to an advertisement notice issued by the ONGC authorities for recruitment of non-executives. The petitioner submitted his application and was selected for appointment in the post of junior technician, bracket diesel, as a PWD candidate, full stop. His certificate of disability issued by the designated
District Disability Board.
District Disability Board
Board consists of chairman and other members.
is valid till the year 2025.
My lord, that will
However,
be exactly.
The respondents are refusing to issue him the order of appointment unless the petitioner furnishes
Permanent disability certificate.
a
My
permanent,
certificate is temporary, that is right,
a permanent disability certificate.
my lord.
His temporary disability certificate is valid till 2025.
That is 25/10 to 25. Date I'm
25/10/2025.
25/10 to 25, valid up to 25/20.
However, despite making the offer of appointment, the ONGC authorities are threatening to cancel the same if the petitioner fails to submit a permanent disability certificate. Full stop. Mr. Borua submits that during the period of validity of the temporary disability certificate, the medical board is reluctant to issue a permanent disability certificate, as a result of which the petitioner is left with no option but to approach this court by filing this writ petition seeking relief. Full stop. In support of his argument, Mr. Borua has invited the attention of this court to the communication dated 21/6/2023 issued by the officials of recruitment and promotion section of the ONGC, Assam SF, a perusal of which goes to show that the offer of employment would stand cancelled if the permanent disability certificate is not produced by the petitioner by 29/6/2023. Ms. S. Sharma, Learned Standing Council, Health and Family Welfare
Respondent
Department, appearing for the respondent number 5, prays for some time to obtain instruction and respond to the allegations made by the petitioner. Full stop. In view of the above, issue notice of motion returnable on 21st of July 2023. Since the respondent number 5 is represented, no formal notice is required to be sent to the said respondent. However, petitioner takes steps for service of notice upon respondent numbers 1 to 4 within 3 days from today by registered post with AD. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby provided that operation of the communication dated 29/6/2023 bracket annexure
That is annexure
Annexure
13,
13
Milord,
shall remain stayed until further orders.
or one post maybe.
What one post?
For my post.
In other
Maybe
words,
reserved. Maybe-
the post
maybe.
for which the writ petitioner has been selected shall be
Maybe
kept
kept.
vacant until further
I
orders.
will do that.
Order stay vacating. Item 12 and 13.
But I mean 13, item number 13.
Well, there is a press stay vacating file, that you will not file objection. We have, for the first time it is taken up today. Will file objection in item number 12.
13 also, my lord.
But I mean 13, my lord, I filed he is enjoying stay order. I filed a stay vacation petition 1 month ago. Till today, they have not filed any affidavit. My feeling is, you know,
Why these are connected?
connected, I don't know, my lord, they are separate. My lord.
Selection of Gaon Bural is for the district of Morigao. The ground taken is a list of villages, same list, lordship, where 10 candidates have been selected. Now, the consideration taken is a letter from the chief minister recommending the candidates. Therefore, for that process, the appointment process was stayed, lordship. It is the same list in both matters.
My lord, whether in that list, my lord, acted upon, we have gone through a selection process. I was selected by the selection committee. I got first, my lord, that's why we appointed, my lord. They're not yet appointed, they're just stay order, my lord. So that's why, my lord, and also in my case, my lord, they objected that I have a criminal case, I have a Bakijai, my lord. We have also, I have everything I have made, my lord. We have no cases, my lord, nothing,
So the writ petition has to be disposed of.
my lord.
So why don't we fix it on
For final disposal.
Yeah, all of-
19 July for final
Yes.
disposal?
My lord.
Lordship, and on the first day, I took up a point on jurisdiction that I will not press because I am unaware of an amendment that had taken place. I will not press that, but independent of that, I have a case for that letter.
All right, so therefore the court has to give a final verdict.
My lord.
Lordship.
So you do one thing, parties can exchange pleadings on or before 17 July. And we'll fix the matter of 20th July.
Deeply objective.
Take down, first,
My lord, and record of the, my lord, selection has to be produced by the.
Yes, yes.
That is very important.
The order is also there, Lordship, for production.
third learned counsel for the parties. The interlocutory applications have been filed, common order, seeking vacation of the interim order passed by this court. Stalling the appointment of Gaon Pradhans on the ground that their selections were made under political influence. However, after hearing the submissions made by learned counsel for the parties, this court is of the opinion that instead of taking up the interlocutory applications, the writ petitions can be disposed of. Both the writ petitions can be disposed of at an early date. First up, the learned counsel for the parties have also agreed to give me a list who is appearing for whom. Learned counsel for the parties have also agreed to said records. In view of the above, register to list both the writ petitions together for admission hearing as a fixed item on 20th of July 2023. Mr. T.C. Chutia, learned additional senior government advocate, Assam, to produce the records of the selection process on the next date fixed. Interim orders passed earlier to continue till the next date.
Okay, what are those steps?
No, steps I have taken yesterday, madam. Yesterday I have
Mr.
taken.
Senior learned counsel for the
Lordship, I have not received the extra copies, Lordship.
I have given, yesterday.
learned counsel for the petitioner submits that he has taken steps yesterday for service of notice upon the respond number.
Respondent number, private respondent as well as government respondent only in the office.
On the private, what is the respondent number?
Respondent number 4, man,
Respond number 4.
by registered post.
Mr. J.K. Goswami by registered post. So J.K. Goswami, learned additional senior government advocate Assam submit that no extra copies have been furnished to him till today. In view of the assurance made by Mr. Sinha that extra copies will be furnished to the learned government advocate Assam during the course of the day, this matter is directed to be listed again after vacation with SR on respond number 4.
Order implement of party item 16.
May I please, your Lordship, this IA has been filed for impeachment of the Joint Secretary to the Government of Assam, HCD, Hills Area Department, Lordship. Lordship,
Impeachment of
Joint Secretary to the Government of Assam, Hills Area Department, Lordship.
Hmm.
As he is a necessary.
He is
party,
of
Lordship.
opposite party number
8, Lordship.
Why you want to impede him?
Lordship, writ petition has been filed for regularization of the petitioner as well as praying for the area salary, Lordship. In one of the occasion.
I heard Mr. D. Thousand Learned Counsel for the applicant, also heard Mr. K. Nayak, Learned SC. You are appearing for Mr. P. Nayak?
7, Lordship.
Hmm.
Finance Department.
Learned SC Finance appearing for the respond number 7. Miss Miss J. Gogoi, Learned Counsel is present for respond numbers
4, 5, 6.
4, 5, 6, and Miss M. Kalita for
1, 2, and 3.
1, 2, and 3. Just it will be opposite parties, huh? So. Just arrange it accordingly. First up. This IA has been filed with a prayer to include the OP number 8 as respond number 8 in the connected read petition. I have perused the statements made in the IA. The learned departmental counsel submit that they would not have any objection if the prayer is allowed. In view of the above and considering the ground on which the prayer is made, the same stands allowed. The OP number 8, namely the Joint Secretary to the Government of Assam, Hill Areas Department, Dispur, Guwahati, is hereby implemented as respond number 8 in the connected read petition. Applicant to furnish a copy of the amended cost title in the read petition within 2 weeks from today. IA stands disposed of.
For admission item 17 and 18.
May I please, your Lordship. Petitioner informed me that petitioner had already expired, Lordship. Petitioner family informed me that petitioner had already expired, Lordship.
Say that.
Yes.
Sometimes
Yes, 17, item 17, Lord. Not pressed, Lord.
not pressed. Item 17. Mr.
PK Google, Lordship.
P.K. Gogoi, Learned Counsel for the petitioner submits that his client has already expired and therefore the read petition be disposed of as not pressed. Mr. U.K. Nayan, Learned Senior Counsel is present on behalf of respond numbers 2, 3, and 4. Whereas Mr. Miss M.D. Bora, Learned Government Advocate Assam, has appeared for the respond number 1. In view of the submission made by Mr. Gogoi, this read petition stands disposed of as not pressed. What will happen to 17?
17, this is 17, my lord.
17,
17,
18.
My lord, I am for the petitioner, my lord. In this case, my lord, I have challenged the selections and appointment of the private respondent in the post of peon and Jarigarok in the establishment of CBI, special the CBI Assam, my lord. My lord, the cleanings are complete, my lord. Immediately, my lord, after vacation, my lord, some difficulty to the.
All right, heard Mr. R. Sharma, Learned Counsel for the petitioner, also heard Mr. M.K. Mishra.
For
Learned
respond number
Counsel
8,
appearing for
13.
the respond numbers 8, 13, and 14. From the cause list, none is appeared for the remaining respondents. It is submitted at the bar that this matter can be disposed of at the stage of admission hearing. In view of the above, registry to list this case again in the first week of August 2023. In the column disposal at the stage of admission hearing, as a fixed item, unquote, as a fixed item. All right.
Item 20.
May it please your lordship. My lord, in this case, petitioner is praying for invalid pension.
Sorry,
Petitioner is praying for invalid pension.
why don't you speak in the microphone? Yes,
Petitioner is praying for invalid pension.
invalid pension.
Yes, because before enrollment, he passed all the physical tests, all written tests, all medical tests. And after selection, when he was sent to military basic training, my lord, he developed one disease, that is seizure disorder. And they have discharged me, my lord, without any benefit. When I filed representation, they have rejected, saying that you have not completed 10 years. But for disability pension, 10 years is not required, my lord. That is my case.
Where is the order by which they have rejected your prayer?
Under page 16, annexure 3 of my writ petition.
Page?
1/6. Annexure 3.
So what is your submission?
My submission is that, my lord, for disability pension or invalid pension, no 10-year service is not required, my lord. Kindly see the rule.
Which is the rule? Please show.
Rule 38, my lord.
Yes, what do you have to say?
My lord, the petitioner was a recruit, my lord. He was undergoing a training, and during the training, this disorder was found, my lord. And as per the appointment letter at page 39, my lord, which you have annexed to our affidavit, my lord, clause 3 says that, my lord, if you fail to successfully complete the recruit training within the stipulated period, as your service is liable to be terminated without any notice and assigning any reason. Lord, he was a recruit, my lord. He was not appointed because only after successfully completing the training, my lord, the appointment order is issued. And
what is the rule says, Mr. Gupta? These
my
are
lord, the rules, my lord, disability pension is given, my lord, when
he's not
it is
asking for-
attributable to service.
Listen, is he asking for disability pension?
Yes. He's asking for disability pension, my lord,
Yes.
because the
So rules are very clear that during the course of service, if there is a disability, bodily
the
or
discharge order is not under challenge.
No,
He has been discharged on
that- that-
that is not under challenge. What is under challenge is, my lord, the rejection of the request for the disability pension, my lord, which we have stated that the seizure disorder is not covered under 1A of the Central Civil Services Extraordinary Pension Rules, my lord. We have annexed the rules in the affidavit, my lord, that is at page 37.
Which are the diseases covered?
Well, the schedule, my lord, I have not annexed, my lord, but section 3A1 states, my lord, that the disablement shall be accepted as due to government service, provided that it is certified that it is due to wound, injury or disease which is attributable to government service,
or existed before or arose.
Bora, this matter will require some
Some hearing will be
in-depth.
required.
You are also not ready with any material except for the rule. Come prepared a little bit. If there is any judgment on this, find out. There will be judgment of Supreme Court or other high courts. Come prepared, we'll hear it again. Miss Bora, learned counsel for the petitioner is present. Also heard Mr. H.K. Gupta, learned counsel appearing for the, yes, Bora, appearing for the response numbers 1 to 3. Having regard to the nature of controversy involved in this writ petition, the matter will require hearing at some length. As such, register to list the matter again for admission hearing after the summer vacation. In the meantime, parties to examine the legal issues and address the court on the point of law.
Fine.
Take that book, take your book.
Obligation.
In this matter, the respondents have already preferred a review, Lordship, and is pending. Lordship, yesterday the review came up and it was heard by Honorable in court number 7, Lordship. So Lordship may kindly post it after vacation. In the meantime, if some order is passed, I will.
Mr. MP Sharma, learned counsel for the petitioner submits that a review petition preferred against the order of this court is pending before the learned single judge. As such, this matter be listed again after the disposal of the review petition. Taking note of the prayer made, Mr. Let it be tagged along with the review petition.
It may be taken.
Taking note of the prayer of Mr. Sharma, this contempt case is directed to be tagged along with the review petition number
194 of 2019.
194 of 2019.
Obliged, Lordship.
Item 22.
My lord, in terms of the order passed lastly on 21/6, my lord, they filed an affidavit, my lord. So I received it yesterday. my lord. So I may be allowed some time to file reply.
Lordship,
Yes, please.
Lordship may go through the last order, Lordship. Adverse observation was made regarding the department, Lordship. Regarding that, I want to give certain clarifications, my lords. Because I am representing a respondent, my lords, who has retired, because of which on the last date, I was not able to apprise or present my case properly on the last date, my lords. Lordship, here is a case where the petitioner's father, he had retired on 85, in the year 1985, my lords. He expired in 2000. There was a period between the between 85 to 2000 where he was required to be given his pension, my lords, which was not given. On the basis of that, the honorable court had observed that an interest has to be given, my lords. On the last date, my lords, I was not able to place that in the year 2003, his arrear pension had already been paid, my lords.
But no interest has been paid.
Let him say.
Lordship,
Take your-
on the last date, my lords, I was not, because I was representing a person who had already retired.
Right, yes,
Lordship,
that's
and in the affidavit, I have asked for exemption of the current contemner number 2, my lords, because he's not looking after the current matter. I have the name of the officers who are actually looking, because this contempt petition never came into the notice of the actual contemners, my lords. So the arrear pension was paid in the year 2003, my lords. Arrear salary, there was a direction to give the arrear salary also. Partly that arrear salary has been paid, and there is a pending amount of 1,41,000, my lords, which can be given to the petitioner itself, provided he furnishes the bank details or his bank details to the principal, my lords. Regarding that, a lot of communications have also been made, my lords. These things I could not place on the last date, my lords. An amount of 1,41,000. If this amount is paid, Lordship, the arrear pension and arrear salary part of the petitioner will be cleared, my lords. Then only the question of the interest that has to be paid, that I apologize, that has to be calculated, my lords. Here I have contacted the officers, my lords, as there's a pension rule. As per the pension rule, the interest can be given to the petitioners, my lords. Arrear salary is already there, my lord. That has been sanctioned. Only the bank details are required. My lords, if the petitioner impletes the officers who are looking after the matter in the process, my lords, because that file has also been moved, my lords, now. But they are not. Lordship will see in the contempt petition, none of the existing officers have been impleted, my lords. That is one problem which I faced on the last date, because of which I could not place my case.
So why don't you give the bank details? They'll transfer the money and then we'll.
That amount, Lordship, that amount can be given at the moment, like instantly, my lords.
My
You
lord,
don't want it.
no, that is not the reason, my lord. 1,41,000 What is the mode of calculation? What is the actual
All
amount?
right.
They have
Mr.
not said.
P.V. Majumdar, learned counsel for the petitioner, also heard Mr. Yashwant.
Moreover, when no interest has been given.
That is being computed right
Mr.
now.
Majumdar submits that a copy of the affidavit filed by the respondent number 2 in terms of the order dated 21/6/2023 has been served upon him only yesterday, and therefore he be granted some time to obtain instruction and file rejoinder. Full stop. Mr. Cholia, learned counsel for the respondent number 2. On the other hand, has made the following submissions. Firstly, that save and accept an amount of rupees 1,41,000. The entire amount of arrear, salary and pension
Has been paid.
payable on account of the deceased father of the petitioner has been already paid. And if the bank details are furnished, the said amount can also be transferred without any further delay. Insofar as the direction to pay interest is concerned, here also the submission of Mr. Chalia is that the file has now been moved for payment of interest.
Yes.
However, since none of the officials responsible for implementation of the court's order were made parties in this contempt case, hence, due to communication gap, there has been unintentional delay in processing the file. First up, be that as it may, taking note of the submission made by learned counsel for both the sides, this matter is directed to be listed again in the 4th week of July 2023. In the meantime, the petitioner may furnish bank details to the respondent number 2.
Lordship, that will be the principal lordship. That is
Bank details to the
principal lordship, respondent number 6 lordship.
respondent number 6, that is the principal of the. he will be
Principal
serving-
Superior Silchar Medical College and Hospital. lordship.
the respondent number 6, to the
That's
principal
number
of
4, right?
Silchar Medical College Hospital Silchar
Let's see.
for facilitating the transfer of the
Remaining areas.
as fund, transfer of the balance portion of area salaries to pension. Full stop.
Item 23.
The order has been complied with, my lord.
Yes, my lord. I have
Mr. A. Bora, learned counsel for the petitioner is present. Mr. S. Bora, learned
It
SC GMC submits that
My lord, I'm here for the contempt petition, my lord. All the 3 respondents.
appearing for the respondents submits that the order of the court has already been complied with and accordingly has produced a copy of the communication dated communication order dated
This is 12, my lord, 9 December, my lord. Down below it is digitally signed 9.
9/12/2022. Mr. Boro has also confirmed the said position in view of the above by retaining a copy of the order dated 9/12/2022 in the record of this case. This contempt case is closed. Public closed.
Item 24.
How many matters are there?
Lordship, the petitioner before your lordship was working as a
Mr. S.S. Borua, 8 weeks. How many contemners? Multiple. Two. Multiple, yes. Yes.
Item 25.
Please, your lordship.
You have Mr.
A.K. Das, my lord.
Mr. A.K. Das. You are not a named advocate here.
No, ma'am. No,
Who's the,
sorry.
whose name is there?
I.S. Laskar,
Mr. I.S.
senior
Laskar.
advocate M. Nazrul.
Multiple 8 weeks.
Item 26.
May I please report, my lord. My lord, order dated 22/2/23 may kindly be seen, my lord. However, subsequent developments have taken place, which has post was stayed kept for me, my lord. I am physically impaired person, my lord. Post was kept vacant, my lord. I have been duly selected, and at the last moment, there was an order passed pursuant to a high court's order where my name was ejected from the list, saying that this name has been ejected because of the order passed by so and so and so. So that is at the impugned order. I'll place it, my lord. Starts from page 84.
So today, why it has been listed?
My lord, this was in February, my lord. Till date, new appointments have already been made except mine. All the appointments have been made except mine that because of the stay order. My lord, we want a finality of this thing, my lord. My lord, hearing will not, I mean, they have to file an affidavit also.
Miller, I'll file affidavit, Miller, come up after vacation.
Excuse me. You are appearing for?
For Guwahati University, respondent number 5 and 6.
Heard Mr. D. Bhattacharya, learned counsel for the petitioner. Peruse the order dated 22/2/2023. Mr. P.J. Fukan, learned counsel for the respondent numbers 5 and 6. Prays for and is granted 4 weeks further time to file affidavit facilitating disposal of the writ petition. Mrs. Burwa, learned government advocate Assam, is present on behalf of the state respondents.
May I make a prayer? Your lordship will kindly fix the date, my lord. Otherwise it becomes very difficult for us to.
Everybody has that complaint.
I understand, my lord.
On the request of learned counsel for the petitioner, let this matter be listed again on 9th of August.
Apply. Most of
All right. Yes.
Made with counsel.
Uh,
In this case, there is a small mistake in the order. That is typographical error at page 12, lordship.
What is the typographical
Name of the petitioner is written as Ratul Roy, ROY. It should be RAY.
RAY.
Yes.
But that is a mistake in the cost title.
Yes, lord.
That cannot be corrected now.
No, it is correctly made in the repetition, lordship. I made it correct. I write it correctly, but in the.
You cannot do it. You have to file amended cost title.
No, I have that in my repetition. I wrote it correctly, lordship. But in the order, when it was entered in the computer, in the code, that was wrongly done. Lordship, I peruse my repetition also.
Let me see. That is petitioner number 4, is it?
Yes.
No, you have written Ratul Roy.
RAY.
ROY you have written. Look at. It cannot be, Mr. Sharma.
Yes, lordship.
Whatever is written will go into CIS and we cannot correct it.
Yes. I shall find my.
Yes. Then why have you made a false statement?
Actually, lordship, in
Wrong
my record,
submission.
in my computer it was written
Oh,
RAY,
that is your
therefore I-
problem.
Yes, lordship. I shall-
Mr. R. Sharma, learned counsel for the applicant, submit that this IA was filed. This IA has been filed with a prayer to correct the surname of the respondent number 4. That is Ratul Roy, whose surname is actually RAY, within quotes, RAY. But I find from the record that the mistake has been committed in the cost title of the writ petition. Full stop. Therefore, unless an amended cost title is filed, the said prayer cannot be allowed. Full stop. Ms. B. Sharma, learned CGC, is present on behalf of the respondents. Taking note of the prayer made in this IA, this interlocutory application stands disposed of by granting leave to the applicant to file amended cost title in the disposed of writ petition being WPC number 2758 of 2023. If such amended writ cost title is filed, the same shall be duly acted upon, whereafter the applicant be furnished fresh copy of the certified copy. Fresh certified copy. Yeah, call it. We'll see. Yes.
Item 28.
Interlocutory application, Nala. By an order dated 31/2023. Lordship issued notice in the main writ petition, Nala. Now, Nala, by the Annexer C order, dated 14/6/2023. I have been discharged. At page 14, Nala.
Discharge as? Discharge
Discharged
from
out of
service.
service.
Why?
Because of the previous order, Nala, the page 13. That IA, Nala, page 13, Nala. The member against whom, the learned member against whom I was attached, he was retired now. He got retired, my lord. Accordingly, my service has been discontinued. Lord, you will see at page 17, my lord, the creation of post.
Where is the order of discharge?
Page 14, my lord. An order dated 14/6/2023.
Yes, yes, Mr. Fine.
Well,
This order was passed during the pendency of this writ petition.
Well, the accountant general have the instruction, my lord, which is there.
Accountant general.
Yes, and the, my lord, the post is co-terminus, my lord. Because once the, my lord,
Page
member,
17, my lord.
member retires, my lord, it's co-terminus. It's the orderly pion.
You file your affidavit, then we'll have to dispose of this matter. If it is co-terminus, then no relief.
Lord, you will find at page 13, the creation of post, page 17.
That's why let them file the affidavit.
Yes, that will file.
We'll fix it immediately on reopening.
Yes.
Such, my lord, date, my lord.
Interim order cannot be passed now.
Because Lord, you will find at page 17, my lord, it is a permanent post.
No.
It is not that, my lord, unlike.
We'll fix it and take it up for disposal on the next day, and on
In the
the basis
meantime,
of
we'll
the
file
affidavit, the writ petition will be disposed of.
Yes.
If it is a permanent post, it will be set aside. Heard
Yes.
Mr. S. Sharma, learned counsel for the petitioner. This IA has been filed with a prayer to set aside the order of dismissal dated 14/6/2023 on the ground that although the applicant writ petitioner was appointed against a permanent post, yet he has been erroneously discharged after the release of the discharged as orderly peon after the release of Srimati Rina Hazarika, member of Furnace Tribunal, bracket first, Udalguri. Full stop. Mr. Payam Lanet, SCFT on the other hand submits that it was a post, the post held by the applicant was coterminous with the member, and that is why he was released. Full stop. The aforesaid aspect of the matter can be examined only after affidavit is brought on record by the opposite parties. As such, this writ petition, this IA along with the writ petition be listed again as a fixed item on 24th of July 2023. It is made clear, in the meantime, the opposite parties may file affidavit. It is made clear that since the applicant writ petitioner is out of his service, the writ petition will be taken up for disposal on the next date fixed. Parties to come prepared accordingly.
So in this case also similar order like 27, that may be passed.
Which is the, what is the
Here,
name?
here, instead of Lokeshwar Mehdi, father's name of the petition number 1, I have written Lokeshwar Mehdi, it is instead of Roy. I have filed amended post at lodge.
Where is Lokeshwar?
Father of petitioner number 1.
Same thing, wrongly, father of petitioner number 1, Navajit Roy, has been wrongly mentioned as Lokeshwar Mehdi within court. Although the correct name ought to have been Lokeshwar Roy. Rest will be same, SS Roy. Dispose of.
My lordship, as per office note dated 26/6/2023, lordship, I have checked the flag few flag consignment in respect of service complete, lordship, in respect to respondent number 3 to 5, 7 to 22, 25, 31, 33, 34, 36 to 38, 40 to 44. I have checked the consignment only. 6, 24 and 39, it is not served as per the consignment. I have to take first step, lordship. And further respondent number 32, 23 and 35, I shall have to take first steps, lordship.
6, 24, 35 plus
24, 39, 23, 35 and 32.
23,
35.
Oh, can you give me the?
No, sorry, 6, 23,
24.
24, 32, 35, 39.
Acha, Mr. SD Procrastin and counsel for the petitioner submits that we can accept the respondent number 6, 23, 24, 32, 35, and 39. The remaining respondents are already served in this week petition. Therefore, he be granted leave to take fresh steps for service of notice upon the said.
Respondent number 2, Lordship.
Mr. S. Datta, learned standing counsel, Panchayat and Rural Development Department, Assam, is present. Since a prayer has been made by the petitioners council to serve the aforesaid respondents through the respondent number 2, to which Mr. Datta has not objected to. Leave is hereby granted. The petitioner to furnish copies of writ petitions along with written up notices for service upon respondent number 6, 23, 24, 32, 35, and 39, and hand over the same to Mr. Datta within 2 weeks from today for service upon the aforesaid respondents. Let these matters be listed again after 4 weeks of orders. Let this matter.
Obliged.
Your Lordship, the matter may be disposed at on merit, Your Lordship.
Today,
Yes, Your Honor.
you're ready.
Yes, Your Honor.
What is the matter about?
This is recruitment, Lordship, where the petitioners, they exercise options like BSF, CRPF and all those, Lordship. So the options that the petitioner had exercised in that category, he did not get.
There is already order of this court in this matter.
There is an order of this court by Honorable Justice Ujjwal Bhuiya, and this is a division bench order, which was carried to the Supreme Court. Supreme Court said, no, once the option is exercised, it will be as per that. It's the order is still Lordship.
All right, where is the order?
It's in the record, Lordship.
All right, you take down heard, Miss
T. Ramsheri.
T. Ramsheri, learned counsel appearing for the writ petitioner, also heard Mr. R.K. D. Chaudhary, learned DSGI appearing for the respondents. Full stop. Aggrieved by non-issuance of order of appointment in favor of the writ petitioners who had participated in the recruitment process initiated by the respondents for filling up the post of constable bracket GD bracket close in the IT, BPF, BSF, CISF, CRPF and SSB, as well as rifleman bracket GD in the Assam Rifles. The petitioners have approached this court internally contending that even if the petitioners did not qualify for appointments to the force opted by them, preferred by them, yet they could have been accommodated in the other forces. This judgment, the single bench says it cannot be done, is it? This High Court has held what?
This High Court has allowed, they can be, but in the Supreme Court, it has been reversed.
The petitioner has relied upon the judgment and order dated 4/1/2016, passed by the learned single judge in WPC number 5520/2012. In support of their case, seeking a writ of mandamus, full stop. However, Mr. R.K. D. Chaudhary has referred to the decision of the Supreme Court rendered in the case of civil appeal number 4585/2018, bracket Union of India and others versus Probir Ghosh and others, PRO BIR, Probir Ghosh and others, to submit that the Supreme Court has set aside the judgment dated 04/01/2016 by holding that once a preference is exercised, no appointment can be made in any other category. Full stop. I peruse the said judgment and find that the issue is squarely covered by the decision of the Supreme Court in the case of Pravir Ghosh and others, bracket Sutra. The petitioner's counsel also could not deny the said assertion of the learned departmental counsel. In view of the above, no relief can be granted by the petitioners as prayed for in this writ petition. This writ petition is accordingly correct.
Item 42 for me.
What are these matters?
My lord, in this case, my lord, we challenge the judgment of the presiding officer industrial tribunal, my lord. We set aside.
Wait, after.
No, my lord, we have recent compromise, my lord. There is already settled, my lord. We have filed an additional affidavit, my lord, in the it's on record.
You call for the additional affidavit.
It's on record, my lord.
It's on record.
Yes, my lord.
Affidavit from
Yeah.
additional affidavit dated 6 April.
Yes, my lord.
Hmm.
So, my lord, the settlement has been reached. We have already given him around 5 lakhs rupees, my lord, 5 lakhs something, my lord, 5,65,708, and he has agreed, my lord. And also we have the PF amount is also to be released, my lord, according to his application. And this settlement, my lord, is valid as per section 18 of the Industrial Dispute Act, my lord. So this writ petition may be closed, my lord.
All right. We take done. Heard Mr. R. Chakraborty, learned counsel appearing for the writ petitioner. Also heard writ petitioner stroke management. Also heard Mr. S.K. Talukdar, learned counsel appearing for the respond number 1 stroke workman.
Workman.
Workman. Full stop. This writ petition is directed against the judgment and order dated
39/2010.
39/2010 passed by the learned labor court at Guwahati. No, labor court at Dibrugarh in reference case number 12 of 2007, holding that the management was not justified in dismissing Sri Probin Gogoi and therefore directed his reinstatement with full back wages. Mr. Chakraborty submits that during the pendency of this writ petition, an out-of-court settlement has been reached in the matter, whereafter a memorandum of settlement, that is an agreement dated, what is the date of the agreement?
5/7/2022, my lord.
5/7/2022. No, it says June 2022. Some such and such date of
Notary, my lord, is notarized on 5/7/2022, my lord.
Agreement executed on 5/7/2022 has been signed by and between the parties, setting at rest the entire dispute. Full stop. Mr. Chakraborty further submits that as per the memorandum of settlement, a sum of rupees 5,65,708 has been paid to the workmen as full and final settlement of the claim, after excluding the PS amount of rupees 1,84,292.39, which will be directly settled by the ATEPF. Since the workman has accepted the amount, nothing survives for adjudication in the writ petition. Mr. Talukdar, counsel for the respondent number 1, has also confirmed the said position.
The Lordship will only record that over telephone he has confirmed. Lord, I have not received any written instruction from him, my lord. I asked him, my lord, to send, but my lord, this is my predicament. He is not responding, my lord, now.
It appears that the memorandum of settlement executed by and between the parties comes within the purview of section 18 of the Industrial Dispute Act. Full stop. Therefore, although Mr. Talukdar submits that he has not received any written communication from his client, although it has been telephonically confirmed that the matter has been settled, I do not find any justifiable grounds to keep the writ petition pending any further. The writ petition is accordingly disposed of as instructions. The LCR be returned, LCR be sent back. Is there a miscase?
No, my lord.
This case was filed by me, my lord. Lordship,
For-
close it, man.
Miss case is also closed. Will be of orders on